80 to 100 FBI agents come to raid a guy's home. They enter through a 6-foot fence, break the front door, they even damage the guy's vehicle, and then they begin their search. When the guy demands to see a search warrant, nobody can produce it. Then the local police shows up. They make the arrests, and they later get a state search warrant to return to the property and search it once again. Based on the second search warrant, the state one, now this individual is facing state charges. In the state system, his lawyers are demanding to see the second search warrant, the state one, because it is based on the probable cause and the information from the federal search warrant. Here's the problem. The federal search warrant is sealed, so nobody can produce it. This is a clean Fourth Amendment case where the feds and the local police team up, but nobody can produce paperwork. So what happens to the state case? Before we go on, I want to thank you for watching me here on YouTube. If you're new to the Lost Stash channel, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to shop.loststash.com and check out some of the merch, including the Do Not Arrest This Person t-shirts. Thanks for watching.
Quick message from Lost Stash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Lost Stash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Lost Stash YouTube page. That's LAWSTACHE.
Today we're discussing a case decided on May 13th, 2026, and it is Cabrera versus the state of Florida. And it is a very good case that shows the relationship between state and federal authorities and when nobody can produce paperwork. But here's what happened. A massive show of force. 80 to 100 FBI agents and their armored vehicles descend on Mr. Cabrera's home. They go through a 6-foot fence, break the front door, even damage Mr. Cabrera's car in the process, and then they begin a search of the house. Mr. Cabrera demands to see the search warrant, but nobody can produce it. When the search is complete, a local state law enforcement officer enters the property, and he sees some roosters and cockfighting paraphernalia. He then wants to talk to Mr. Cabrera and hear the most famous last words in Fourth Amendment. Mr. Cabrera says, "I haven't committed a crime, so I have nothing to hide." Don't be like Mr. Cabrera. Never speak to law enforcement. Because based on the statements and what the state law enforcement officer saw, he gets a state search warrant. So the next day, he returns to the property and searches it once again. Mr. Cabrera is then charged in the state system with a few counts of cockfighting paraphernalia and animal cruelty. His defense lawyers quickly realize that the search warrant that the state authorities got was based on the fact that the feds had a search warrant. But here's the problem. Nobody can produce the federal search warrant. It is under seal. And so the judge, the prosecutor, is not producing that warrant. So when it comes to the suppression motion, nobody has seen the federal search warrant. Not the judge, not the defense lawyers, not the prosecutor, not even the state detective. He testifies that he was there on the property because he believed the federal authorities had a search warrant, but he also never saw that search warrant. Here's what happened in the lower court. The lower court says suppression motion denied. Why? Because they said, well, because of this huge show of force, the federal authorities clearly had a reason to be on the property. They must have had probable cause to enter. And because of that, well, the good faith exception can be used here for the state local authorities. Because they can look and they go, oh, wait a second, there's so many people, so many cops on the property, so many FBI agents, 80 to 100 of them. They must have a reason to be here. So I can enter as well and work together. And so in the lower level, the suppression motion is denied. But of course this case goes to the appellate level, and the appellate court says the reverse. The Fourth Amendment protects against unreasonable searches and seizures, and generally speaking, officers need to have a warrant before they conduct a search. But that warrant must be based on probable cause. Here, the state search warrant is based on probable cause, and in that statement, the probable cause says that the federal authorities had reason to be on the property. So again, where is the federal search warrant? The Court of Appeals reverses, and for three good reasons. Number one, the burden of proof. When the search is conducted without the consent of the defendant, the burden is on the state to show that the search was lawful. And here, the defense points out that the local detective had no business entering the property because at that point, he did not have a search warrant and did not even see the federal search warrant. And even now, we still don't have the federal search warrant because it's under seal. And so the state cannot show that he lawfully entered the property when he initially searched it. Number two, under the United States Supreme Court decision Leon, officers can rely on what later can become a defective search warrant. So, which means that if their reliance is objectively reasonable, the evidence will stay. This is often called the good faith exception. So again, in order for the good faith exception to apply, we have to look at the four corners of the search warrant to see whether there's any deficiencies. But here again, we don't even have a copy of the federal search warrant. So the court cannot conduct the test and look at the four corners of the document. Why? Because there is no document. And number three, the collective knowledge doctrine. Officers can rely on each other's knowledge, meaning if one officer has probable cause, he can relay that information to the other officer. And even if he doesn't relay that information, it is presumed that all the officers know all the information together. They're working as a team, meaning, again, that the state authorities can work together with federal authorities. But here, the collective knowledge doctrine doesn't apply because the detective Rodriguez testified that he never saw the federal warrant, he didn't know what it was about, and nobody on the federal side even ever told him what was contained in the search warrant on the federal side. So without any knowledge, where's the collective knowledge? Here we don't have the federal search warrant. So the collective knowledge doesn't apply. For all of these three reasons, all of the information that the state authorities collected must be suppressed under Fruits of the Poisonous Tree doctrine. If you enjoyed this video, give it a thumbs up. If you're new to Lost Hash channel, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to shop.losthash.com and check out some of the merch, including the Do Not Arrest This Person t-shirts. Thanks for watching, and I'll see you next Wednesday for another deep dive on another criminal case.